Welcome to Legal Resources Radio, where we invite you into the world of social justice, advocacy, and public interest law. Throughout this podcast series, we'll share stories, insights, and expert advice from our dedicated team at the Legal Resources Centre, as well as from our valued guests. In each episode, we'll dive into the legal landscape, tackle pressing social issues, and aim to empower you with the knowledge to make a difference. Whether you're a community activist, a legal professional, passionate about social justice, or just curious, this is the place for you. So wherever you are, washing dishes, at work, on the bus, train, or plane, or just relaxing at home, plug in your headphones, take a deep breath, and get ready to begin.
Welcome to this week's episode of Legal Resources Radio, our second podcast in a series unpacking sexual corruption, what it is and what the law is ultimately failing to do about it. If you'll recall, in our previous episode, we discussed what sexual corruption actually was, speaking to Sakuna from Awaken, and spoke a little bit about the very important work that they're doing on the ground in communities, raising awareness about sexual corruption. Today, we're going to pivot a bit and we're going to talk and really engage with the legal framework around sexual corruption. I am joined by LRC attorney Muyenga, and we are going to be in conversation with Prof Sope Williams from Stellenbosch University, a public procurement professor who is an expert in anti-corruption work generally, but specifically in the field of sexual corruption. Prof, thank you so much for taking the time to be with us today. We really appreciate it. Before we get started, I know we just said before, we had a whole episode about what sexual corruption is, and I would highly recommend that everyone, if you haven't, take a moment, listen to that one first. But just before we get started, I suppose it would be really helpful to hear from you what you, in a nutshell, actually understand from the concept of sexual corruption.
Okay, that's a great question, a great way to start, and thank you for having me on the podcast. So sexual corruption is a form of corruption where sex or sexual acts are the currency of the bribe. So we all understand what bribery is. We understand corruption as this a gratification or something given to get something else in the public sector, but also in the private sector. But when we talk about sexual corruption, the currency that is being exchanged is not money or any other kind of benefits. It is, a sexual act, sexual favors, sexual intercourse, whatever you want to call it. So that's what it is in a nutshell.
Yeah, which I think as well raises very important issues and concerns around imbalances of power and coercion within that dynamic. I know, Muyenga, we've spoken a lot about this, and I'd love to hear your thoughts on how we see power play out from within sexual corruption.
Yeah, I think that one of the important things to keep in mind is that often when it comes to sexual corruption, and I suppose issues that arose in our earlier podcasts, that a lot of the time it's about rights denials.
Yeah.
People are being coerced into sexual favors to obtain housing, to obtain water, to obtain other basic services, which I'm sure many of the listeners would know as well. It's like part of our constitution. Yeah. So because of how serious the topic is, something that has struck us at LRC is that how can this not appear anywhere in our legal framework? Like the term sexual corruption, you can't find it across any of our statutes. Yeah. And I think that one of the, first places one could look to see, like, maybe there's something to work with is the Sexual Offences and Related Matters Act, which is the primary legislation dealing with issues around sexual offences.
Yeah.
And I just wanted to get your thoughts, Prof. Do you think that could be a good starting point for addressing issues of sexual corruption?
Yeah, in a way it could be, but maybe your first question is, how does it not appear in our legal framework?
Yes,
and I'll tell you why. Because the law is, as most parts of our society are, but law especially, is androcentric, which means that it is developed and considered through a very male lens.
Yeah.
And sexual corruption is predominantly an issue that affects women. It does affect men and boys, but the predominant victims are women. So when you look at the legal framework in its entirety, you see that and because men were, the first people in law and the first lawyers and judges, etc., the first legislative drafters, you see that the law is always coming from that perspective, the male perspective. So sexual corruption is not a male issue, in the sense of the victims being men. So that's why we don't really see it. So and that's a problem, not just with corruption. So the corruption law is androcentric. It thinks about bribery from that perspective of men exchanging money with each other to get businesses or whatever. It doesn't really have a gendered lens. It doesn't really think of, okay, how does corruption affect women or affect marginalized groups or other people in society. So that's that. Then the other thing is as to whether the sexual offences legislation can work. It can, to the extent that, of course, sexual corruption is a corruption offence, but it's also a sexual violence offence, right? And of course, the sexual offences legislation deals with sexual violence. And the sexual offences legislation has its benefits in the way it can deal with sexual corruption, because it's one of the few pieces of legislation that deal with the issue of consent in a very nuanced way. So the sexual offences legislation says, there's a sexual offence where there is intimidation, there's threats, there's deception, there's coercion. So it doesn't just need violence, right? In terms of looking at what consent is, it doesn't conflate consent with a lack of
it could be a
violence.
very good starting point.
It could be a starting point. But where the problem then comes in is that the sexual offence legislation, the kinds of offences that are recognised are things like rape, like sexual assault, prostitution, statutory rape, so child rape and all that. So if what happens to you falls short of those, then the sexual offences legislation wouldn't work for you. So the consent part is something we can borrow, but the rest, you have to have been a victim of these very specific and often violent types of offences.
Okay. So then would you say that when it comes to the issue of coercion within the Sexual Offences and Related Matters Act framework, that it can adequately capture that there's no consent in cases where, I don't know, a place in a housing list is on the line, or access to water is on the line? Okay.
So I would say we can borrow the consent piece from the sexual offences legislation, because as I said, consent is dealt with. If we needed to look at issues of consent for sexual corruption, then the sexual offences legislation talks about consent, as I said, in a very nuanced way, understanding that consent doesn't have to be violence for there to be a lack of consent. So that you may not consent because there's a life sustaining issue on the line. You're being denied water. You don't have consent if your options are no water or or this. So the consent piece is important. But if we were to look at sexual corruption more broadly, and some of the stuff that I advocate in my work and in my report, is the fact that we shouldn't even be looking at consents, that all the focus should be on the public official. So if a person is in a position, then they shouldn't be allowed to abuse that position. Because when we start talking about consent, especially for sexual offences, we can go down a very slippery slope where it then is like, okay, well, did you consent or not? Is it consensual? And what did you get out of it? Did you get a benefit? And, then the question they always ask, what were you wearing? That, so for me, it's like, actually, when you're dealing with a public official who has a public duty, right, and is supposed to abide by a code of public ethics, and is bound by law.
That's an important reminder.
Right? It's bound by law to act in a certain way. It's bound by the Corruption Act, not to act in a certain way. Then for me, looking at the victims, even if they benefited unduly, right? Even if they got benefits that they were not entitled to, for me, I feel that conversation is relevant because the public sector has broken their duty as a public servant. So while the consent in sexual offences is good, I think for sexual corruption, we shouldn't even open that kind of worms, because then you make it harder for victims. And at the end of the day, whether the victim is morally right or wrong or benefited or didn't, that's not the person who is bound by law is the public official.
Exactly.
And they shouldn't breach the law.
And I think as well, it's important to take that perspective, because what undermines any consideration of consent or anything to that degree really is this imbalance of power and this abuse of power that public officials are quite unique in holding. And I think SORMA is a great piece of legislation for being able to address issues around coercion and sexual violence between individuals, but also sexual corruption is something that exists within a system. There's definitely a public-facing aspect to it, which SORMA is never intended to try and address, nor ever could it. And we see that currently in our legislative framework with PRECA, which is our primary piece of legislation that deals with corruption-related offences, and essentially is the legislation that criminalises corruption. And what's quite interesting with PRECA is it provides a general criminalisation of corrupt dealings. I think what we think of normally when we say corruption, like you said, Prof, often this transactional exchange of funds, but also provides specific criminalisation for certain specific instances of corruption. Now, notably, sexual corruption doesn't feature there. But more concerningly, PRECA looks, I think, at this corrupt transaction as something that is transactional in a way that it attaches equal blameworthiness to both parties. Could you talk to us a little bit about what you think could be shortcomings with that approach if we try to move sexual corruption under PRECA currently?
Okay. So a couple of things. So like you've said, PRECA has a general offense of corruption, and it's marginally useful as a way of addressing sexual corruption because it talks about, public official or an official, actually, because it also applies in the private sector, receiving a benefit or gratification. And we have case law from the early 90s that tells us that there was a case of sexual corruption where where the courts decided that a sexual act or sexual intercourse could form that currency of a bribe, and someone was prosecuted for that. However, PRECA, like all anti-corruption legislation worldwide, not just in South Africa, as you said, there's this idea of a fair exchange. So PRECA criminalizes the giver and the receiver of the bribe. Right? Because as I said, because of the androcentric nature of corruption legislation, the thinking is two men of equal status who are trying to, support each other in this way, or, there's this element of equal reciprocity. But so PRECA criminalizes the giver and the receiver, which could make sense when you're thinking about a person giving a bribe to get a government contract. It could make sense. But when you're thinking about sexual corruption, the imbalance of power always means that it isn't a fair exchange. And even if the woman victim in this case did get something that she wasn't entitled to, there still is an imbalance of power. So PRECA doesn't address that imbalance. It assumes that there's a fair exchange, and it criminalizes both parties. So, of course, you think about the cases of sexual corruption that Awaken and Zakona's team have, reported on and heard about. Students in universities, women trying to get RDP housing, women trying to get immigration permits, women trying to get their water delivered. That is not and these are not people of equal status. These are people who have absolutely no power in the terms of this particular transaction. So PRECA doesn't account for that. And by putting both parties on an equal footing, by criminalizing it, then it means that when you have cases of sexual corruption, there's so many barriers to reporting, but then the fact that the victim will then be potentially also a criminal accomplice means that you're never going to get it addressed with as a corruption offense, because no victim is going to report.
In effect, the victim will be self-reporting,
Exactly.
saying that I was party to a criminal act.
Exactly, and that's not going to happen. And especially because sexual corruption is very interesting in South Africa, because we always have this idea that it happens mainly to women who are vulnerable, and it does. It really does. Women who need to rely on basic public services, but it also happens to women who are more have greater socioeconomic status. So women in procurement, women trying to access other government benefits. So it's and so you think the women who are vulnerable, of course, have other barriers like education and fear and lack of resources to but even women who are highly educated will still face the same barrier.
Yeah.
Women who are wealthy will still face the same barrier because at the end of the day, if I report, I'm going to be penalized as well.
Yeah, and I think, I mean, what you said earlier, Prof, it's so apt when you look at it. It's a glaring example of the gendered nature of corruption and a glaring example of people in the legislature failing to consider that power is a very gendered concept and its manifestation will have gendered impacts.
Yeah.
And I think as well, Muyenga, your reference to SORMA earlier, and also Prof, your brilliant description of how nuanced SORMA is when it comes to consent is a very good example of this. SORMA was a recent piece of legislation that really came off the back of legal reform and development. And I think ideally what we would like to see, at least what our C's work focuses on here, I think what a lot of people in this space focus on, is recognizing precariat is not good enough, recognizing our legal system falls short, and trying to reform it. Trying to make sure that sexual corruption is recognized as a standalone offense, trying to ensure that victims are protected, and that we can have people come forward and report, and importantly, then the perpetrators are held accountable. What do you think might be a good example of where we've seen that done well in a way that takes into account complicated social dynamics and doesn't try to inadvertently harm someone that the law is supposed to protect?
Okay, so that's a great question because, I mean, recently, so I'll say in the last, decade or so, a lot of countries have reformed their corruption legislation to take sexual corruption into account, the peculiarities of it. Because I said, as the world becomes more open to understanding that, women's are not just little men, women have specific needs, right? Then they're creating legislation that addresses gendered nature of corruption, of criminal law, etc., etc. So in terms of sexual corruption, we have a few countries that have changed their Corruption Act to feature a standalone offense of sexual corruption. So on the continent, Tanzania is one. So they have in their anti-corruption law, they have a specific offense of, basically sexual bribery. And it's defined as an abuse when someone abuses their position to obtain a sexual act, right? So the issue of consent isn't mentioned and all that. So they just focus on the public official. Did he abuse his power? So that's on the continent. Croatia also has similar legislation, but they sort of nuanced it that there would be an offense of sort of sexual corruption or sexual bribery if the public official, if there was an imbalance of power. And so they bring in, I suppose, the issue of consent, and there's a denial of consent if the person that the official is dealing with is someone in a vulnerable position. Right? So if that happens, so there has to be the sexual act or the request for the sexual act, and then there has to be this imbalance of power. And once that is done, then the victim is not criminalized. Right? So presumably, it means that if the person is not in a vulnerable position, then she's criminalized.
Which is problematic.
So it's not great, but it's it's a start. And I think the third one I'll mention is Indonesia. So they recently reformed their their anti-corruption and sexual offenses or violence against women legislation, and within that, they have a very broad framework that deals with the offense. So they criminalize sexual corruption. They deal with issues of consent. They even deal with how it should be reported, that it must be a human rights and a gendered sensitive way of receiving those reports. So they have probably the most comprehensive legislation dealing with this. So it's not just about sexual corruption, but it's about gendered violence, sexual violence more broadly. So a number of countries are doing some work on it. There's some work going on in Uganda, in Brazil, etc., and in India as well. But I think Tanzania, Croatia, and especially Indonesia stand out as like really examples.
I mean, you've done a lot of your research here has looked at how the government is failing to deal with this. And I think listening to what you're saying as well, those are some really good developments. And I'm honestly I think saddened that we don't maybe see a similar move within the South African context. Do you think that there's any particular reason why we're maybe not seeing this reform
Yeah, I think just building up on that
I
question
think,
that Claire asked, like,
yeah,
we're known as a society where sexual assault and sexual violations are very, very prominent
yeah,
across a whole lot of different
mm,
metrics. You
mm,
would think that South Africa might be one of the first countries
yes,
to take these
yeah,
steps that you outlined
yeah.
that's going on in other places.
Especially with our progressive constitution.
Yeah. So I mean, South Africa is hugely progressive. I think so. I think in terms of sexual corruption, a couple of things up until quite recently, it wasn't named,
Yeah.
and many people didn't recognize it for what it was. And because we have a lot of sexual violence in South Africa, the types of sexual offenses that are lower down the food chain, if you like, so compared to things like femicide and gendered violence against
Yeah.
women, those are top priorities, right? We have one of the highest incidences of rape in the world, one of the highest incidences of femicide in the world. So attention is on that.
Yeah.
So attention is not on the lesser, if you like, offenses against women when women are dying. So that's one piece of it. And the other piece is that because sexual corruption, especially, is so normalized that many people just feel it's, it is what it is. It's just part of life. And women have absorbed it and have learned how to live with it and to manage it. And the perpetrators are in positions of power,
Yeah.
right? So,
Yeah.
so and culturally, because there's a lot of sexual violence, and culturally there's a lot of sexual offenses against women more broadly, it it just doesn't have the visibility that other types of offenses have, even though it's so pervasive. And as I said, culturally people just feel that it's not. I mean, if you think about the recent case with the judge precedents in the Eastern Cape High Court,
Yeah.
where he used culture to explain this alleged harassment of his secretary. And even when the judgment was given, they were like, well, what he had done, whether it was consensual, that there isn't a power imbalance just because he's in a position of power, which
That's the definition of a power imbalance,
which was
me.
very strange.
Yeah.
And also you even see, and of course the tribunal did the work as best they could, but you even see that there is a lack of understanding of how power dynamics work, of how things land with women, because the decision makers are men. They cannot understand that. They actually don't have a frame of reference for knowing that if someone is in this position, even if it looks consensual, it's not, because there's a power balance, because there's a power dynamic.
Exactly.
Yeah.
Right? And so they were like, oh, he didn't pull rank. But you have rank. You don't need to pull it.
it's
The rank is there. Right?
Exactly.
Do you understand? So it's like when you think about all those issues and that are colliding, then you understand why this hasn't been, been front of mind, especially from the corruption point of view. And with corruption, of course, we have a lot of corruption
Yes.
as well. And because we have, even though South Africa is progressive, it's very strange because you have formal progression in terms of the law and all that, but in terms of women's personal experiences, you don't see a lot of change.
No.
So, the Bill of Rights is there. You have, the nuances with the sexual offenses legislation. You have, the PEPUDA, the Gender Equality Act. You have great formal equality, but very little personal equality for gender equality for women, and very little change in women's experiences of violence and gendered inequality.
Yeah, I mean, that's very true.
I was just going to say that I think it's really interesting as we started this conversation, like looking at like different legal frameworks, but are now speaking about like the fact that these institutions that survivors would have to rely upon to support them through the process, to hold those accountable, have these very, very strong biases as well.
Yeah.
So that lends me to think that maybe in this matter, like a two-pronged approach is necessary. The one is to like get legislation that explicitly recognizes it as an issue, like as you said, the issues of SORMA and PRECA, but then also dealing with the fact that even when individuals who maybe not in the same sexual corruption, I guess, circumstances, but when they come forward to share their story, to show how they've been violated, there's just a lack of understanding among institutions about exactly what has happened.
And I think on that too, we forget as well sometimes that law leads society. if we don't have something reflected in law as something bad and worth criminalizing, how do we expect society to shift its culture? Especially if the law right now says that the victims are on equal path for blame readiness. Prof, thank you so much for taking the time to talk to us. I think especially what you say here about trying to unpack the real gendered impact of corruption is so important. It feels almost like constantly in South Africa we're at all of these watershed moments, but I think again corruption has come back into the public discourse in a very real way. And I hope that maybe we can start to see, when we reflect on corruption and the abuse of power within government, that we start to introduce gender perceptions and perspectives, to actually then see that part of the conversation come to the fore. It's a conversation we feel like we always have about corruption, but never from this angle. So thank you that you had this conversation with us. I think it was very enlightening and illuminating. And Muyenga, thank you as well. And thank you to our listeners. It's something new, and it's important, as always, to say the silent part out loud here. And that really is talking about and unpacking sexual corruption. So thank you for listening, and we hope you've learned something new as well.
Thank you for tuning in to Legal Resources Radio. We hope you enjoyed today's episode and gained some valuable insights. If you did, or even if you didn't, please remember to subscribe, rate, and leave a review. Follow us on Twitter, Facebook, and Instagram at Legal Resources SA, or visit our website at lrc.org.za for updates and exclusive content on the incredible work our team is doing. We'll see you on the next episode of Legal Resources Radio. Stay curious, stay inspired, and keep up the good fight.